of the Middle East and North Africa Working Group of Parliamentarians for Global Action on the fight against impunity, promoting accountability mechanisms and the effective implementation of the Rome Statute. I was in Baghdad and Beirut shortly before the UK lockdown in March last year. And it has been a terrible year for all countries afflicted by the pandemic. And it has meant that we have had to work in a different way in our respective countries. My name is Jeremy Purvis. I'm a member of the British House of Lords and a member of supporting the work of the UK branch of PGA. In my chamber in the British Parliament, we now have hybrid sittings, a mix of members who are there physically and those who are taking part remotely. And there have been some elements where the remote working has allowed innovation and different ways of working and have been positive, but there are some where there have been negative. And it means that we have to work remotely in this session. So many of us are experienced in these meetings, but some housekeeping first, please. For those that are joining, please stay muted until you are speaking. And we have simultaneous translation, which you can see in the button at the bottom for English or Arabic. And the interpreters ask us all to speak more slowly than normal. I am from Scotland, and we in Scotland speak very fast. And not always English people can understand what we say. So we will try even harder to speak slower for the interpretation. We want this to be interactive when we open to the interactive discussions. So please use the chat box and the raise the hand function. And a combination of myself and David and the PGA team will be monitoring the chat box in order that colleagues are able to participate when they want. So the final thing I'd say for introduction is just congratulate PGA for bringing this event together. It is very timely as countries are both adjusting to the challenges that the pandemic have faced, but are now considering the future as we come out of the pandemic. And in the UK, we have spent quite a lot of parliamentary time debating some of the justice, civil liberties, and law and order consequences of emergency measures that the government have taken, emergency legislation with restrictions on civil liberties, and the powers of the executive, primarily in data capture of personal and public behavior. And we are aware that there are long-term consequences on rule of law and civil liberty as a result of the pandemic. You may have seen just in the UK significant challenges on policing demonstrations of those who are opposed to restrictions on civil liberties. And we have reluctantly extended emergency powers of the government. But we are continuing to debate these issues. So I'm very pleased to be able to listen to both experiences from our friends across the Middle East and North Africa, and from those that PGA have brought together to share direct experience from the ICC on the specific challenges in the MENA region. David, I'd like to hand over to you to introduce some of the work of PGA and this session before we open up to our experts. Thank you very much.
Thank you very much, Jeremy, and it's really an honor to be with you today in this setting. As much as we would like to come back to work in person, we really feel compelled. We feel compelled in PGA that we must serve our membership and provide continuity of our work. So some of you attended our Consultative Assembly of Parliamentarians on the ICC and the rule of law in November. Some of you even addressed it, and we are really honored to have some of the most important experts in this field joining us from 3 continents today. Let me say that our board member Amina Melainine couldn't be with us today from Morocco due to these COVID-19 measures of restriction that are going to start soon. She decided to anticipate a very happy event for her, which is a marriage, to today. So this decision was dictated really by the urgency of the situation, but I take this as a very happy sign that happy things can happen notwithstanding all the difficulties. So we should take that on board. Now, however, what is the purpose of this working group? We met many times, and in the July of 2020, we met with a small group of parliamentarians from Morocco, Tunisia, and Lebanon. So this is the part 2. We decided to break it into 2 subgroups to have it more interactive and also to respond to the different sensitivities. PGA works with parliamentarians from elected parliament, and in 2 cases, we have the honor to have today 2 important parliamentarians from Palestine and Yemen. Your parliaments could not have elections due to the ongoing conflicts, due to the even the coup d'etat in Yemen and the difficult transition in the post-Saleh, post-Arab Spring season, where we, however, continued very strongly to support the work of Yemeni parliamentarians from all sides. And instead, in Palestine, we see now that there is an electoral process ongoing. So we are even more thankful to Honorable Qawasmi for being with us, because we know that you are preparing for the next electoral season, which is so important for the future of Palestine. So, and in parallel, of course, we have members from Iraq and Jordan joining us. These are countries that are where the democratic institutions are fully functioning in a vibrant manner. However, for different reasons, Jordan joined the Rome Statute but didn't implement it in the domestic law, while Iraq worked many years on these issues but did not yet decide whether to join or not. So I really hope that this meeting of today will be helpful to relaunch the debate. Now, PGA is an organization that is based on individual membership, and it's really up to the individual parliamentarian to take action and launch initiatives. In the face of mass atrocities committed during World War II and in the Cold War era, our members decided to launch this campaign back in 1989, well before the establishment of the ICC, well before even the creation of special tribunals by the United Nations Security Council for the former Yugoslavia and Rwanda and other experiments in this field. But the first time that this idea regained momentum was in 1991 in the face of certain mass atrocities committed in northern Iraq, with a lot of victims from the side of the Kurdish people. So as you may imagine, there is a particular attachment today, and I'm very happy to have Mr. Ali Omar Fattah with us, because we know that he holds a very important office in the parliament, and through him we really look forward to work with the relevant committees. In the past, our understanding was, because we will not have a speaker from Iraq, but I will try to fill the gap here. In the past, Honorable Faig Sheikh Ali initiated an initiative in support of the Rome Statute ratification in Iraq. But, and this gained a lot of support among many parliamentarians and also among, with the President of the Republic. But the Prime Minister of the time said, not yet, not now. This was during the time in which Mosul was an occupied city by an armed group called Daesh. And now the situation is totally different. So we really think that it could be rediscussed and reapproached. A final word is towards the future. We really hope that PGA will be able to reconvene meetings in the future. So let's look at this meeting just as a starting point, one where our team, without which, of course, this meeting could have not taken place. I really thank them for the enormous work that they have done to put it together. But this is just a starting point. We will want to continue and assist you and help you to interact with your peers from other regions, countries, and continents. And of course, maybe one technical advice to all our speakers. I know that they are very learned. They know much more than we can imagine, and they will be able to demonstrate today. But I invite you maybe not to use acronyms so that all of us can fully understand without risks of misunderstanding. Thank you so much, and we remain available, of course, during the course of the session.
Thank you, David. It's my pleasure now to introduce the first panel, and then we will be able to have a discussion based on their remarks. The first panel is focusing on the fight against impunity at the international, regional, and national level. And I'm delighted that we have Mr. Rod Rastan, the acting head of the preliminary examination section of the Office of the Prosecutor at the ICC. And we also have, and Nada, please forgive my pronunciation of your name, but Ms. Nada Kiswanson Weinhoidong, I think we just say Nada, for your presentation. But Rod, if you're able to take the floor first, we'll hear your remarks, please.
Great. Well, thank you very much for the invitation, and it's wonderful to join the PGA again. I'm grateful for the opportunity to participate. I look like I should be able to speak Arabic, but I'm from Iran originally and grew up in the UK, so my knowledge of Arabic is quite limited, so you'll forgive me if I speak in English. I've been asked to talk about the reasons for the lack of jurisdiction of the ICC over alleged mass atrocities committed in Syria and Iraq. David, I mean, as you know, I'm very happy to keep this interactive also. So if there are questions or issues you want to engage in immediately, as we're a small group, I think we can keep it quite fluid. And of course, Nada will address the issue of Palestine. So I think I won't make any comments on that, but maybe we'll come back to it later if needed. In terms of the basic issue, I'm sure you're all familiar. The ICC is an international criminal court, but it's not truly international yet in the sense of not being truly global, as you all know, because the ICC is not able to investigate and prosecute everywhere in the world. So I guess we would say that the term International Criminal Court as the designation is also aspirational. We hope and we promote universality of the treaty, of course. We hope that one day, and I think this is the goal of the drafters, that one day the ICC will be able to address all allegations in all parts of the world. But right now, this aspect, this limitation on our ability to investigate everything is perhaps one of the main criticisms of the court, and one of the main problems, if you like, with accountability, is that, of course, the ICC is based on a treaty, as you know, and states have to join the treaty to grant jurisdiction over their territory or their nationals. Or, as you know, the alternative is for other than states joining or on an ad hoc basis accepting the jurisdiction of the courts, the alternative, as you know, is for the Security Council to refer situations to the court. And as you know, the Security Council's power to refer situations to the court can be very controversial, because the Security Council is, of course, a political body, and it will decide to refer some matters and not others. So it means that sometimes the court is caught up in these issues, The court itself doesn't get involved in that voting. Of course, we are the recipient of referrals. But as you know, the Security Council has referred 2 situations to the court from your region, actually, Libya and Sudan, if Sudan is considered to be part of the wider MENA region, but refused to refer the situation of Syria to the court because of the veto exercise. So this means that in the case of a situation like Syria, which is not a state party, has not joined the court, has not accepted the jurisdiction of court, and the Security Council has not referred the situation, the court doesn't have jurisdiction as such. And the same applies to Iraq. Iraq not being a state party, not having lodged a declaration accepting the court's jurisdiction, has not joined the court. Also, in the absence of the Security Council, there is no jurisdiction. So the conversation could finish there, but of course there are other possibilities that particularly at the Office of the Prosecutor, we do try to examine. One of the things that we've been looking at in both Iraq and Syria is whether or not the allegations of crimes have been committed by the nationals of state parties. So as you know, of course, in the context of the war in Iraq and the initial invasion of Iraq by the coalition of forces, it resulted in Iraq being occupied by international forces in different zones, and in the southern zone, Basra was under UK occupation, and there were allegations that members of the UK armed forces committed, in particular in relation to persons in detention, acts constituting torture or inhumane treatment. This was not unique to, the allegations weren't unique to UK. As you know, there were also similar allegations against US forces in Iraq, as well as allegations that Iraqis themselves on different sides of the conflict had also committed a large number of different types of crimes within the court's jurisdiction. But because we don't have territorial jurisdiction, the only thing that we could look at for Iraq were the allegations relating to the state party nationals, in this case, the UK personnel. And I'll come back to that in a second. In relation to Syria, similarly, we don't have territorial jurisdiction, but in relation particularly to the activities of Daesh or ISIS, as you know, of course, many allegations of foreign fighters coming to fight in Iraq and Syria. And in particular amongst those European nationals who would have been ICC state party nationals, nationals from Tunisia, a notorious national from Georgia. So these are all state parties. So again, we looked into whether or not this might form a basis for jurisdiction. And secondly, the other aspect that we're still currently looking at, and I think could be also an important area to consider, is what is happening in neighboring countries. And so Jordan, being a state party, offers the possibility to examine whether or not any of the crimes allegedly occurring in Syria are spilling over into neighboring Jordan. And the basis to do this is something that we argued in the context of Bangladesh and Myanmar. You might be familiar that in that situation, we have a state, Myanmar, which is not a state party, where the crimes are alleged to be committed, in this case against a minority population called the Rohingya. I'm sure you've heard of it, the situation. And neighboring Bangladesh, where vast numbers of Rohingya had fled. And although we had no jurisdiction of what was happening in Bangladesh, one of the crimes alleged was deportation, that the members of the Myanmar armed forces were intentionally deporting, pushing people over the border or creating the circumstances whereby they would cross the border, and in the process accusing them of being foreigners and telling them to go home back to where they came from and so on. Very derogatory language, but clearly intending to deport them out of Myanmar into neighboring Bangladesh. And we went to the court, we argued that surely when somebody crosses the border, the crime occurs across both borders. So we argued that the crime of deportation in this case is commenced in Myanmar, but completes in Bangladesh. And in this way, at least part of the crime occurs on the territory of Bangladesh. And this way we would have jurisdiction. Those of you who had studied law or familiarity with it, you'll recall the classic example that's often given in textbooks about jurisdiction is what happens when somebody shoots a gun across a border and somebody, so from state A, they shoot the gun and the person dies in territory B across the border. Where is the crime occurring? Is it occurring in state A or state B, where the crime begins or where the crime ends? And of course, the answer is the crime occurs in both states. Either state could exercise jurisdiction for where the crime is commenced or for where the crime is committed, is completed. And this is, you know, a classic example. And states do exercise jurisdiction on this basis when part of a crime is committed on their territory. So we argued it should be the same for the ICC. We said this is not controversial at the national level. Why should it be controversial at the ICC? And the judges accepted that submission. And this is why we are now investigating crimes that have their origin in Myanmar, which is not a state party, but have consequences in terms of part of the crime being committed in the territory of neighboring Bangladesh. So, of course, since we made that submission, immediately people said to us, well, why don't you do the same thing in Syria, where people are being deported, alleged to be being deported into neighboring Jordan. So this is a matter that we have been looking into. The facts that we've been looking into have not been as immediately clear as they were for Bangladesh, Myanmar, but we are in the process of trying to form a view on this. We mentioned this in our last annual report that we're looking into this to see whether or not the underlying facts are made out. If they were, then this could lead to the possibility of the OTP inquiring further and examining this as possible way to exercise jurisdiction over what's happening in Syria, focused on the alleged crime of deportation of Syrian civilians as a crime against humanity into neighboring Jordan, and any acts which are related to that. It could be, for example, other acts such as persecution or denial of the right to return, or other inhumane acts. It could be possible. But this is something that the office, just to clarify, we haven't formed a final view on. We're in the process of engaging with different stakeholders who have some more information on this. We're looking at this currently, and it's a possibility. But you can see that all of these ways of addressing the situation, they provide some possibilities to look into these allegations, but it's also still very limited. Much more ideal, obviously, would be if countries like Iraq and Syria were state parties, or had, if not become state parties, accepted the court's jurisdiction, so invited the court to exercise its jurisdiction on an ad hoc basis, lodging a declaration. Then we wouldn't need to look into only who are the nationals of state parties who may be there in Iraq and Syria, who are the foreign fighters or the allegations against British soldiers and so on, or looking into the confined issue of those areas where people have been deported into Jordan, but we couldn't look into other things that were happening in Syria. So all of this it's positive in terms of providing some perspective on accountability, but ideally, of course, it's not the best way to approach these underlying crimes. And so, of course, the court as a whole, and particularly the presidency, and one of my colleagues, Matthias from presidency, is here. The court very much, of course, together with PGA, who have been so instrumental in this process, is always encouraging universality, meaning widespread adherence, accession, membership of the Rome Statute, so that the court doesn't have to either explain why it can't investigate, or find other possible, sometimes indirect routes to assert its jurisdiction, when it would be far more beneficial if it could do so. Of course, maybe the last thing I'll say is, of course, in the MENA region, or in the broader MENA region, the court has been actively engaged in the last years, as you know. So if we think of the broader MENA region, as I mentioned, Libya and Sudan, of course, are under investigation by the court. The situation in Palestine has moved recently into investigation. if you include Afghanistan as part of the wider MENA region, we also have Afghanistan, which is, I know it's, I was looking on Wikipedia to make sure who is included in MENA, and I saw that the IMF includes it as Afghanistan, but others don't. But the point is that in the region, there some states have, or in the wider region, neighboring region, some states, of course, have joined the Rome Statute. And the consequence is that the court is able to carry out its activities and open investigations. But in other situations where the court, where the states have not joined the Rome Statute, it's much more sometimes difficult, or if not, sometimes impossible for the court to assert its jurisdiction. So then, of course, we take the responsibility as the court to have to explain this, but I think ultimately, as I'm sure you agree, the ultimate responsibility, of course, resides with the parliamentarians and the members of the executive and so on, who must formulate the view on whether or not they wish to exercise their sovereign prerogatives to join the Rome Statute. And in that process, of course, sometimes questions come up about what does this mean? Sometimes there's confusion about what does joining the Rome Statute mean? Sometimes mixing up of what the ICC is looking into in terms of what other bodies might look into. So again, on these aspects also, of course, the court, as do other experts and members of the PGA, I'm sure, can also provide help. Great, I'll stop there. Thank you.
Rod, thank you very much. I think we will be picking up some of those points in the discussion. As you know, the issue with the British servicemen has been of controversy within the UK. We are currently debating a controversial piece of legislation of the Overseas Operations Bill, which is a presumption against prosecution, including of torture and of murder of British servicemen and women overseas, not of rape, and a period of limitation for 5 years. I and my party colleagues are opposing this legislation. The opposition is opposing it. It's a high level of controversy at the moment. So there are other political consequences to some of these decisions too. So thank you, Rod, very much. And we're very happy to debate these issues. But next is Ms. Nada Kiswanson, the legal representative of the victims of the situation in Palestine. So we'll hear specifically of the Palestinian case. Nada, over to you, please.
Thank you so much. Good afternoon, everyone. Are you all hearing me okay? Perfect. So it's my absolute pleasure to address you today during the 8th session of the PGA Working Group on the Fight Against Impunity. As a Palestinian and as a Jordanian, I recognize the importance of events such as these that provide legislators, lawyers, and civil society groups with the opportunity to connect, exchange ideas, and share visions on international criminal justice in the MENA region. I've been invited to address key developments in the situation in Palestine at the International Criminal Court. On 5 February 2021, the pretrial chamber of the International Criminal Court ruled on the court's territorial jurisdiction in the situation of Palestine in response to a request by the prosecutor of 20 December 2019. The pretrial chamber's ruling addressed two principal questions. One, made the court exercise jurisdiction over the situation in Palestine? And if so, what is the scope of the court's territorial jurisdiction? In summary, the pretrial chamber decided by majority that the court has jurisdiction over the situation because Palestine acceded to the Rome Statute in a correct and ordinary manner. In other words, the chamber interpreted the term state as state party. The chamber also found that the scope of the court's jurisdiction extends to the Palestinian territory occupied by Israel in 1967, namely the Gaza Strip and the West Bank, including East Jerusalem. The Chamber makes it clear in its decision that it cannot pronounce itself on the status of Palestinian statehood under international law, and its findings on the court's jurisdiction do not prejudge or adjudicate the borders. Indeed, the ruling narrowly examines the matter of the court's own competence. In my view, the pretrial chamber's decision is indispensable to any effort that seeks to have the court dispense criminal justice in relation to the situation in Palestine. The decision assures the prosecutor that it can investigate credible allegations of war crimes and crimes against humanity committed on the Palestinian territory since June 2014. It is during the investigation stage that cases are developed and accused persons are identified. It's worth recalling that the prosecutor held, when she announced the conclusion of the preliminary examination in the situation in Palestine on 20 December 2019, that she believes that there exists a reasonable basis to believe that Rome Statute crimes have been committed on the Palestinian territory. Notably, the prosecutor's preliminary examination report of 2020 recalls that there exists a reasonable basis to believe that both the Israeli Defense Forces and Palestinian armed groups committed, amongst other, the war crime of willful killing, and that Israeli authorities have committed the war crime of transfer of Israeli civilians into the occupied territory. The decision is also, in my view, important because it reminds states parties that they're under an obligation to cooperate with the court. That obligation to cooperate is only triggered at the point that the investigation is initiated. And in my opinion, the decision ought to preempt non-cooperation because a state considers that the prosecutor is proceeding on questionable jurisdictional grounds. I have devoted more than a decade of my legal career to the occupation of Palestine. And what I have learned during that time is never to underestimate the personal, national, regional, and international significance of the conflict. The attention that the recent litigation on the Palestine situation garnered highlights just this. During the litigation process that resulted in the just mentioned decision, more than 40 amici curiae filed submissions before the pretrial chamber. States such as Germany, Austria, and Uganda all weighed in on the issue before the chamber, as did the League of Arab States and the Organization of Islamic Cooperation. We do not have time today to go through all of these submissions, but I would like to briefly summarize the observations of the League of Arab States and the Organization of Islamic Cooperation, since this meeting is to address impunity in the MENA region. The Organization of Islamic Cooperation took the position that Palestine is the only legitimate sovereign over the Gaza Strip and the West Bank, including East Jerusalem, and that Palestinian self-determination is to be exercised over these lands. It further held that the occupation does not change this. The League of Arab States adopted very similar arguments, and it added that peace and justice are not mutually exclusive notions. It said, and I quote, "Advancing accountability for international crimes and serving the cause of justice would facilitate and indeed serve peace efforts." Furthermore, around 1,000 individual victims were represented in the proceeding. I'm honored myself to have represented the views of 770 of those victims from across the Palestinian territory. And this active and inclusive participation in the proceeding is truly remarkable. The litigation at the court provides a channel for the expression of the victim's pain and suffering, and it encourages a peaceful, regulated, and judicial settlement of contentious legal disputes. But the process at the court is cumbersome and it is lengthy. The prosecutor opened the preliminary examination in January 2015. It took the prosecution close to 5 years to conclude the preliminary examination, and an additional year was spent litigating the matter of the court's jurisdiction before the pretrial chamber. On 3 March 2021, the prosecutor announced that the investigation has been initiated, but she alerted to operational challenges caused by the pandemic, the limited resources available to her office, and the current heavy workload. Palestinian victims have said time and again that the International Criminal Court is the only judicial body able to hold to account those individuals responsible for the crimes committed against them. The International Criminal Court is, after all, an independent, transparent, and specialized court. For the sake of these victims, for the sake of the court's reputation and standing, and for the sake of peace and security, the international community, and not least the countries in the MENA region, must help the prosecutor find a way to overcome the obstacles that she has referred to. I'd leave it there, and I remain available for the discussion. Thank you so much.
Thank you, Nada. Thank you very much. So there's an opportunity now for some minutes to make points from the floor or to ask any questions of Rod or Nada. So please, participants, if you wish to, please raise your hand by using the button or place a question in the chat box. I can't see at the moment anyone doing that. So apart from David, and then Sahar Qawasmi. So maybe with your permission, David, maybe we could go to Palestine first, so Sahar's question, and then we'll come over to you, David. So Sahar, please.
Thank you, Mr. President. Thank you for the invitation for this session. I have a small question. We know that ICC, it is independent court. It is regulated by Rome Statute, and who signed in this statute, it is applied on him. But if the other who violate human rights, who make crimes, he is not part of this statute. He is, his impunity is kept because he is not part of this statute. I believe that the international community, they have to find the tools at least, and some instruments, how to make this ICC, which is, which reflects a real tendency toward implementing of international law and for keeping human rights to be applicable and working as a court, not just to be for countries who are small countries who are not influential on the whole political system in general. Everybody is supposed to be, every country is supposed to be, every state is supposed to be under the, at least to be without double standards, under the law, below the law. This is the issue, how to keep justice in general, but practically it is not. So how we can find more tools to bring the others to this court and to make the facilities to the others to interfere in this court, because without all countries being in this court, especially the powerful who are powerful countries, I think still the actions of this court or the decisions of this court still not applicable. So this is my question.
Thank you very much. So maybe I could ask Rod to address that first, and then of course, if there's any comments from Nada.
Sure, I'll try. I'm sure Nada will have also some insights into this, and probably PGA members and David as well. Absolutely, it's a very important point about universality, that how other states can join. I think it's interesting to see also what were the arguments given in the national parliamentary debates for those states that did join. And as you know, of course, there are many large and small countries that are outside of the court, but also some large and small countries that are inside the court. And for those that joined, one of the issues was to dispel the misinformation that this was a kind of human rights court that would supervise decisions taken by national prosecutors in every case that they deal with. Now, this is not to say that human rights is a bad word. Of course, human rights is at the core of the effort to combat impunity. But the ICC also is not that kind of court. We're not a supervisory body. And I think for the states that joined, they're aware that the ICC will intervene in situations of massive atrocities, not with cases of routine kind of incidents that may happen at the national level, which may trigger human rights concerns, but are not necessarily on that scale. So there's the issue of gravity and scale of the kind of cases the ICC will deal with. But also, I think most importantly, is the issue of complementarity. As you know, the reason that the court could be established and so many states could join is because the ICC is not set up to replace national courts. It's there to respect them and to instead complement them, in meaning that this is a supplementary forum. So for many of the countries involved, the main argument to join in the national debate was that there is no threat to national sovereignty and no risk of intervention, as long as the state's own courts, as long as our own courts are acting effectively. And this is the desire of many of the countries, obviously, that joined, that they are champions of domestic justice and that they have nothing to fear from the ICC. And joining the ICC would not only send a powerful message, but it also would strengthen a commitment to the rule of law. And some countries have even gone further and said that the ICC is part of the national legal system, that the ICC is merely an extension of how the national system applies accountability, and therefore should not be seen as a foreign other threat, but as part of domestic accountability processes. So I think this is also an important aspect of the perception of threat and fear that can often be generated versus the reality. And of course, also, as we've seen, different national bodies have different responses. Sometimes some national ministries are very much in favor of joining. Often, for example, the Ministry of Foreign Affairs and Ministry of Justice will be very much in favor. Sometimes the Ministry of Defense is more cautious, or Ministry of Interior. And again, this often comes from a misperception or paranoia or anxiety created about what the ICC will examine. So some of these things can be resolved through dialogue. Some of them can be resolved by, like the PGA is doing, by having parliamentarians talk to each other to share their experiences of what worked, what was convincing, what wasn't. And some of it relates to looking at the practice of the court. What has the court investigated? What has it opened? And where has it applied complementarity and so on? So I think those are not really satisfying answers. The last point, sorry, I would just make, of course, the court can exercise jurisdiction over nationals of countries that are not parties to their own statute. Of course, this is what the court has been looking into in a number of situations where foreigners, if you like, who are not members of the court, have committed crimes on the territory of state parties. So as you know, this does allow the court to examine what happens on the territory of state parties, even if the state of the nationality of the alleged perpetrator is not a state party. So there is that possibility, but absolutely, the better solution would be universality.
Thank you, Rod. Nada, any comments? And I was asked just to remind us all to keep our talking pace so that the interpreters can do it. But Nada, I don't think that applies to you. You were speaking at perfect pace before. It's very clear, thank you. But over to you, Nada.
I don't have anything particular to add to what Rod said. If I would just highlight that if we indeed want to move to a situation, to a reality where there are no perpetrators that are being shielded from justice, then we need to ensure that more and more states actually join the court. This is key. So that's the only thing that I would say to that.
Thank you. So there are three now, contributors for David, Abdul Muaz Dewan from Yemen and Susan Power. Perhaps if we hear the comments from the three, and then a little opportunity for Nada and Rod to make any comments or respond. But David, please.
Yes, very briefly, because Rod was enlightening, and actually let me, Rod, thank you once again. Rod addressed the second session of this working group in Bahrain more than 13 years ago, in the pre-Arab Spring and Syria conflict era. And when we started this working group in Cairo in 2005, we were well before the pre-Arab Spring and current era. We were told why President Mubarak at that time said no to his most valid jurists exported even in the United States of America, his Minister of Justice, Speaker of Parliament Sorur, who was a prominent lawyer and a member of PJA. Why did he say no to the ratification of Egypt? There was a big book prepared for his ratification. At that time, only Jordan was the only country in the MENA region that had ratified the Rome Statute. Today, we also have Tunisia after the Arab Spring and Palestine. And President Mubarak said, no way, I am a military man. I need to be able to wipe out whoever, the terrorists, he called them. They're all terrorists, all those who are against a certain government of the day, correct? So that's the problem we are having. When you have oppressive regime who believe that the law should apply only to those who are opposing the government and not to themselves. But that's why we have the Rome Statute. In the past, we had ad hoc tribunals imposed, which was better than nothing, because in Europe we had, I am Italian, we created fascism, and in Europe we created National Socialism. We did the Holocaust, and we brought the worst tragedy to the world, World War II, the crime of aggression in the rest of Europe. All this was adjudicated in Nuremberg, which was a tribunal of the Allied powers against the Axis power. Better some justice than nothing. Nuremberg is an important precedent. After the end of the Cold War, we created ad hoc tribunals with decisions by the Security Council to check on specific cases like the Rwandan genocide or the disintegration of former Yugoslavia. Now, since 1998, we have a multilateral treaty, the Rome Statute, which was ratified today by 123 states, which is a big number, including some middle-sized or major powers, depending how you consider the UK, France, Brazil. But we are still confronted with some reluctance by other states. So it's really a long-term process that we are embarked, but I think we already made progress from Nuremberg and from the ad hoc tribunals. And a final point that I want to make, look at the Lebanon situation. As a result of that Cairo meeting of 2005, in 2006, on the 30th of May 2006, Prime Minister Siniora at that time in Beirut was ready to join the Rome Statute. He received the Austrian ambassador to Lebanon, who was the president of the European Union at that time. And he said to him, I'm ready to do it, but I still have two obstacles that are blocking me because we need consensus in Lebanon. And the obstacles are Hezbollah and the US embassy. All the others would like us to join, all the political parties, myself, But these two allies and parties in our society don't like the idea. They say no. They didn't, and the result was that now in Lebanon you cannot apply territorially the Rome Statute. But as Rod said, if an Italian peacekeeper, because you know between Lebanon and Israel there are Italian and French peacekeepers, if any Italian or French national would commit a war crime, the court could exercise jurisdiction in a complementary way to the jurisdiction that any state that is competent could exercise, could be Italy, France, or Israel, or Lebanon itself. So the system is there, is available, we just need to make it become universal.
Thank you, David. Now for our Yemen PGA member, Abdul Muez Douan, please.
شكرا جزيلا. في الحقيقة في البداية دعوني أتقدم بالشكر الجزيل للبرلمانيون من أجل التحرك العالمي على إتاحة هذه الفرصة. والحقيقة أن اليمن أو البرلمان اليمني حاول قبل نشوب الحرب أن يمضي نحو الانضمام إلى نظام روما، لكن اليوم ونحن على مشارف السنة السابعة للحرب في اليمن في حالة غياب الدولة وتعطل عمل المؤسسات، أنا أتساءل سؤال من شقين يمكن أن أجد الإجابة عليهما.
حسنا جميعا إنه صغير.
الآن تمام؟ أوكي. أنا لدي سؤالين أتمنى أن أجد لهما بعض الإجابات أثناء هذه الورشة وربما أجد. القضية الأولى، في حالة غياب الدولة وتعطل المؤسسات بأكملها، كيف يمكن للبرلمانيين كأفراد وليس كمؤسسة حينما تغيب المؤسسات بأكملها، مؤسسات الدولة وتتعطل، ما الذي يمكن أن يقوم به البرلمانيون في مثل هذه أو هكذا حالة؟ هذا الأمر الأول. الأمر الآخر، الدول التي لم تنضم إلى نظام روما وتعاني من جرائم حرب كما هو الحاصل اليوم في اليمن، هنالك جرائم يعني متسلسلة ومتتابعة لا تطال العشرات، تطال الملايين. هل الإفلات من العقاب في هذه الحالة هو المصير لكل هذه الجرائم؟ السؤال، هل توجد فجوات أو مداخل يمكن الاستفادة منها في مثل هذه الحالة التي نعيشها في اليمن؟ شكرا جزيلا لكم.
Shukran. I didn't hear any simultaneous English translation, but I'm not sure if the participants did or whether the interpreters are able to help. Thank you. Thank you very much. That's such a good question that Rod will address. I think I'll answer shortly. Susan Power, over to you, please, for your comment or question.
Thanks very much. I'm Susan Power from Al-Haq, a Palestinian NGO. And of course, we welcome, of course, the investigation that was announced, but we still have remaining concerns. The executive order in the United States has not been rescinded. And of course, there's the persons who are designated still remain. And we're also concerned about the issues around materially assisting the court and persons who may be designated, including human rights organizations, lawyers, anybody who's materially assisting the prosecutor may be designated under the US executive order. So this puts this has a chilling effect on the ability to work with the court, I'm interested to know what especially with the people here today, what kind of political pressure might be brought to bear on the United States in relation to this executive order and with Joe Biden and the need to rescind this executive order. And we're also worried about Israel and Israel's already targeting even our field researchers in the occupied territory, and our field researchers have been in the Jordan Valley, have been the day after the investigation was announced, were told that they couldn't go further into the Jordan Valley, that it was a military protected area, and also the ambassadors were denied movement in Palestine. So we're worried about these different impacts. And the third thing we're also worried about is the potential delays around, especially with Article 18 and the notification. And I suppose this would be addressed to Rod Rastan. What are we looking at now in terms of the investigation? We've already been delayed a year at the pre-trial chamber, and with the notification procedure and the issues around complementarity and Article 18, could we see further delays, and what delays are we looking at? And also politically, do you think there is a potential of like an Article 16 deferral as well? We'd be quite worried about that. We've heard about it in certain contexts, some people talking about this. I wonder, is it a real political issue that we should be thinking about? Thank you.
Thank you, Susan. I'll go to Nada first and then Rod, and I want to abuse the privilege of the chair by asking a question myself to Rod, which is Nada's point which is linked with Susan, the time that it takes for these processes. Are there anything that parliamentarians in countries can do that would be linked with trying to secure additional resources or staffing for shortening the period of time that the ICC will carry out its work? If you're able to address all of the points that have been raised, I would be very grateful. Nada, over to you first, please, and then Rod.
All right, thank you. So were you referring the last question to me, just to be sure? Or were you referring to all?
My question was being directly towards Rod.
Right, that's what I thought.
Emphasize your point, which I thought I took on board.
Yeah, that's what I thought. I mean, the only thing, I think Rod is best placed to address the questions around Yemen, but also the questions from Susan about the executive order and the situations in terms of where we stand in terms of any deferral of the investigation. The only minor thing that came to my mind, and that's in relation to Yemen, is that what we've learned from the Palestine situation is that it is possible to allow the court to exercise jurisdiction retroactively. And maybe this is something that Yemen would, and members of parliament from Yemen would like to entertain, because it may be that there's still a possibility for the court to become active even on crimes that have already been committed. And this is something that happened in Palestine, where the state joined in 2015, but it allowed the court jurisdiction back to June 2014. So this is just something that I'd like to invite some thought on.
Thank you. Rod, before I ask you just to have a final comment on this part, I see Sahar's hand raised. Sahar, are you wanting to make an additional comment, or your hand's still up? So maybe Sahar, and then Rod, you could wrap up the whole, and then we move to the next panel. Sahar, please.
I want to speak in Arabic, please. يعني كلامي أنا بدي أتحدث في محكمة الجنايات الدولية، هي محكمة للنظر في القضايا العالقة ما بين الدول، وهي التي تنطبق أيضا على الصراع الموجود ما بين دولة فلسطين والاحتلال الإسرائيلي، وحتى على قرارات الشرعية الدولية التي هي استعملت كمرجعية في المفاوضات. وحين ذهبت فلسطين إلى محكمة الجنايات الدولية هي تبحث عن حقوق موجودة في القانون الدولي. على سبيل المثال حسب القانون، حسب اتفاقيات جنيف متعددة، الاحتلال طويل الأمد هو يعتبر جريمة حرب، الاستعمار أو الاستيطان ويعتبر جريمة حرب، وكثير من القضايا التي تصنف حسب القانون الدولي كجرائم حرب ولكن تمارس. ونحن نعرف كيف أن هناك تسييس لكثير من المؤسسات الدولية في أخذ القرارات، يعني النظر في هذا الصراع بشكل محايد لا يوجد حتى الآن، وهناك ازدواجية بالمعايير. كيف ممكن لمحكمة الجناية الدولية ونحن كفلسطينيين نثق بهذا الدور ونحن نطلع أن يكون هناك مؤسسات تعمل بشكل منظم تحمي حقوق الدول، تحمي القانون الدولي وتحمي حقوق الإنسان؟ حين نطلع إلى هذا ونذهب نحن إلى محكمة الجناية الدولية ونحن شاكرين أنها اعتبرت أنها تنطبق على أرض فلسطين للنظر في القضايا، ولكن حين يمنعها على سبيل المثال دولة إسرائيل في الدخول أو عمل التحقيقات، ما هي الأشياء التي ممكن أن تجعل من هذه المحكمة في مثل قضية فلسطين وغيرها من القضايا العالقة في العالم هي قضايا يعني محكمة ذات وزن وذات تأثير؟ نحن نعرف مثلا الولايات المتحدة الأمريكية ليست عضو، روسيا ليست عضو، الصين ليست عضو، إسرائيل ليست عضو. إذا كيف نحن كفلسطينيين نعاني من الخرق في القانون الدولي الذي ينتهك حقوقنا على المستوى الجمعي وعلى المستوى الفردي؟ كيف يمكن لنا كفلسطينيين أن نصل بشكل سلمي، بشكل عبر القانون الدولي، بشكل عمل دبلوماسي إلى حقوقنا الوطنية دون أن يكون خسائر من كلا الطرفين؟ هذا السؤال اللي حتى نعتبر أن هذه المحكمة قد تؤدي إلى نتائج في النهاية تنهي النزاعات. هذا ما نطلع إليه. فلهذا يعني إحنا موجودين لأن نحلم أن يكون هناك شيء من العدالة، ونحن كفلسطينيين جربنا كل الوسائل ولكن لا نزال نثق بالمجتمع الدولي، وعندنا قيادة سياسية تثق أن المجتمع الدولي قادر على إنهاء هذه الحالة وبأخذ الموقف الدولي من هذا الصراع وليس الموقف الفلسطيني أو الرواية الفلسطينية من هذا الصراع. كيف ممكن لمحكمة الجنايات الدولية أن تضيف بشكل موضوعي وهناك إسرائيل تمنعها من الدخول، تمنعها من التحقيقات؟ هل ممكن أن يكون هناك أي إجراء آخر موازي لهذا يدعم دور محكمة الجنايات الدولية؟ هذا سؤال.
شكرا جزيلا. I think we will be helped with the interpreters now. Thank you. And I think that, nope. Thank you very much. I think we will, before we close, we will come on to some of those specific areas later, maybe from David, that could help with that. But Rod, over to you. A lot of areas, but I know you will be able to address them very well.
Thank you, Jeremy. I'll try to speak slowly, and I'm aware that we're running over into the next panel. I'll try to cover as many issues as I can, but I'm aware that indeed many of these issues will likely come up in other sessions. So I'll also defer probably broad discussion to later. On the representative from Yemen, I mean, absolutely, as Nada mentions, there is a possibility for a retroactive application back until July 2002, and a number of states have exercised that option in different ways. The court is currently looking at one set of allegations concerning Yemen, which relates to arms exporters from several European countries who have sold arms to the parties to the conflict. The allegation is that they've done so knowingly in awareness that these arms are being used to commit widespread IHL violations of international humanitarian law. I mean, this is publicly known. This is why I'm referring to it, and we've confirmed that we've received this. We have yet to form a view on it, but it's resulted also in some interesting litigation in countries like Italy, Germany, and the UK, with either parliamentarians calling for a revisiting of the applicable oversight given to either government sales to countries or the way in which the government will review commercial contracts in terms of exporting arms to countries where they're alleged to be these crimes are alleged to be committed. So, I mean, I know this debate has come up recently in a number of countries, also in the UK, in context of other countries also. So this remains an interesting area to examine. It's about accessory liability in theory. We're looking at it to see whether or not this might be something that might fall within the jurisdiction of the court or not. But again, it shows that there are ways to try to tackle some of these issues, but it's not ideal. Ideally, the court could go to the core matter and examine jurisdiction directly by having the states join. But certainly, I think it's important that parliamentarians keep this issue alive. And as you can see, parliamentarians from third countries may also be very important in this discussion. Parliamentarians from Italy or Germany, the UK, where the allegations reside, for example, and others, could be just as influential in helping to shape what's happening in Yemen, perhaps to some extent, as Yemeni parliamentarians. So I commend the PGA's approach in relation to bringing you together. On Al-Haq's question in relation to the executive order, as you know, the court has spoken out quite vigorously against the executive orders, and we've heard a lot of positive language about a desire to reset the relationship and to revisit those orders. So we are waiting to see what will result. At the same time, of course, the court as a whole has been stressing that these executive orders are unacceptable and should be removed. On Article 18, so this is the process whereby at the opening of an investigation, the prosecutor must send out letters under Article 18 of the statute, inviting any state party or any other state that with jurisdiction to inform the court if they themselves are doing national proceedings. There is a 30-day limit to do so. So the letters were sent out on the 9th of April. So 30 days, the expiry date is under the statute. States have to then revert to us and tell us if they are doing so. If they are doing so, there is a possibility to seek additional information, to get clarification and so on. But otherwise, it is foreseen as a swift procedure. It's never really been litigated in the past. We only have the example so far that it's been triggered in the Afghanistan situation. And there it's taken some time because it happened in the middle of the beginning of the COVID pandemic. There was at the time, what appeared to be indeed a legitimate request from the Afghan authorities to give them additional time to submit. They did then submit. They first of all lodged within 30 days a request, so that came in, and then they furnished additional information. And since then, we've been having an exchange to clarify some matters, and we will form a view, of course, on that in due course. So in the case of the Palestine investigation or the situation, the 30 days will run, and we'll see if any requests come in. And of course, the requests must relate to proceedings that the state itself is conducting. And the way that we understand Article 18, that it relates to specific cases that the state is investigating. That's the scope of what they can request to be deferred. So it's not in a blanket manner, the way that we understand it. But these issues obviously could be litigated in the future. In terms of the delays, yeah, of course we appreciate that there has been a lot of delays. The main cause of the final delay for us in filing the request was that it took us some time to formulate the request for a jurisdictional ruling. I think, as mentioned before, I think Nada mentioned also, I think there are some benefits to having obtained this ruling now in advance of the investigation. Of course, we were aware that we could have just proceeded without seeking a ruling. We were satisfied the conditions were met, but we saw the benefits of clearing this most controversial issue, perhaps, or at least to obtain judicial clarification on it prior to proceeding, so that we wouldn't get a constant questioning of whether or not we had a legal basis to do what we said we were doing, because we would be proceeding without any chamber authorization. So it did take more time. I'd asked for a swift decision. The decision ended up taking a little over a year, but ultimately the decision is now in. So this is where we stand. We are generally trying to also speed up our activities in pre-examinations and investigations. I think one of the real hindrances, and this comes to the question from Lord Purvis, one of the main hindrances of the court is our sheer inability to cope with so much activity. I mean, we have said this more recently and more forcefully, although it's a message that the prosecutor has been saying throughout her term, that there's a chronic mismatch between what we're asked to do and what we're given to achieve that. So we're chronically underfunded. This might sound like a little bit of complaining from a prosecutor's office, but just to give you a sense, the Office of the Prosecutor has a budget of 45 million euros. The court as a whole around 150 million euros. 45 million euros might not sound too bad, but for example, Amnesty International and Human Rights Watch, two of the leading NGOs in the world that do reports calling for investigations, each of them has a larger budget than the Office of the Prosecutor of the ICC. Human Rights Watch has a budget of around 60 million euros over. Amnesty International has a budget of over 200 million euros. Now, they do tremendously important work, but it just shows that non-governmental organizations calling for international investigations have a greater capacity and budget than the actual court to which those allegations end up and the investigations that are actually conducted to a criminal law standard. So you can imagine that 45 million euros, although not nothing, is quite chronically mismatched against something like 13 or 14 investigations that are currently pending before the court, and new investigations that are warranting investigation, that are warranting opening. I mean, in December, we actually said that Nigeria and Ukraine are also ready to open, but we simply can't open them because we don't have the budget, but we're working towards that. And so the Palestine statement does indeed also echo some of that. I mean, we do underline that however daunting these challenges, I'm reading from it, it says that this cannot divert us from ultimately discharging our mandate. So of course, the prosecutor's office will seek to do what it can with its means. Of course, we are not unable to carry out our mandate, but it is a very severe handicap, the lack of adequate funding. So if there's something that can be done in terms of shortening the timetables or allowing the court to overcome some of these challenges, which was also a question earlier, certainly the ability of parliamentarians to raise this matter of what kind of court has been established and what kind of means have been given to it is hugely important, because this is an argument or a debate that we have every year with our Assembly of State Parties and with our committees on budget and finance, in the sense that state parties have repeatedly told the court that there is no more money, that there is zero growth, and the court must manage within its means, and the court must prioritize, meaning that the court must decide within this fixed budget line what it wants to do, but there is no appetite from state parties to provide more means. And obviously, a very valid argument is often given that at the national level, many governments and many ministries have also taken budget cuts, and this is difficult times, and so on. But for the court, it is a persisting problem, and I think the problem will only increase going forwards as more and more of these situations warrant investigation. And this is certainly a problem the new prosecutor will have to confront as well. How do you respond adequately with high quality investigations, allowing you to not only make allegations, but to prove them beyond reasonable doubt at trial to a conviction standard? How do you do that with such limited means? So if parliamentarians are able to shape that discourse and to raise the need for a proper, sound capacity for the court to be able to carry out this mandate, then we would be ready to fulfill and to implement that. Lacking that, we will do our best within our means, but it will mean that many of these situations simply cannot be addressed in the manner that we would wish, and we will have to seize opportunities and prioritize as we can. But very often it's very difficult to make those kind of choices, but we'll try.
Rod, thank you very much for a very comprehensive answer. Let's move on to our next panel now, and I'm delighted that the Honourable Wafa Bani Mustafa from Jordan is joining us. I've been to Jerash and Jordan many times, and I know the leadership that Her Excellency has been providing on this topic for a number of years. So really delighted to introduce her in this panel on implementing international crimes. And then we will hear from Melissa Vipile from the PGA. But Your Excellency first, we're delighted to hear from you, please.
شكرا جزيلا جيرمي، ودائما مرحب فيك بالأردن. سعيدة جدا بوجودي معكم في برلمانيين من أجل التحرك العالمي، وسعيدة برؤية ديفيد وسحر وبعض الزملاء الذين أعرفهم سابقا. وأعتقد بأن دور البرلمانيين جدا مهم. أنا حاليا عضو سابق في البرلمان الأردني، وسعيدة أيضا بوجود أحد العضوات الحاليات السيدة المحامية دينا البشير الموجودة معنا. وأود أن أتكلم في شقين: الشق المتعلق بالتشريع الأردني، والشق المتعلق بماذا فعلنا نحن في ائتلاف البرلمانيات من الدول العربية، لأن لدينا مشروع اتفاقية عربية باعتقادي بأنه يصب في إطار أيضا المساعدة على عدم الإفلات من العقاب والتأسيس لثقافة المساءلة والمحاسبة عن كافة الأفعال والجرائم. سأطلعكم على أيضا جزء من ما فعلناه وما قدمناه، وهذه الاتفاقية التي أنهت المراجعة الأولى لدى لجنة المرأة في الجامعة العربية، والآن هي في اللجنة الخاصة بحقوق الإنسان، ونأمل يعني أن يكون هنالك إقرار حقيقي لها. في الحقيقة لابد من الإشارة أن نظام روما الأساسي هو أداة فريدة لمكافحة الإفلات من العقاب وعلى جميع الجرائم الدولية، وخاصة جرائم العنف الجنسي والجرائم المبنية على النوع الاجتماعي المرتكبة ضد النساء والفتيات. الأردن واحة أمان، ولكنه محاط بالكثير من الصراعات واستقبل الكثير من اللاجئين. والأردن بلدي الذي أعتز به واحد من الدول التي، أو هو الدولة العربية الأولى التي صادقت على نظام روما الأساسي في 11 أبريل عام 2002 كدولة طرف في المحكمة الجنائية الدولية. وهذا المصادقة المبكرة دليل على ثقافة احترام حقوق سيادة القانون وحقوق الإنسان واحترام القانون الدولي وأدواته وآلياته المتعددة والمختلفة في الأردن ومن قبل النظام الأردني. ولا بد من الإشارة أنه في الإطار التاريخي أيضا دعم الأردن في البداية ومنذ عام 2007 تطبيق نظام روما الأساسي من خلال إطار قانوني وطني. وفعلا بدأت وزارة الخارجية في ذلك الوقت صياغة تشريع تنفيذي شامل من أجل أن يكون هنالك توطين لهذا النظام ضمن تشريع محدد. وهذه واحدة من الطرق اللي انتهجتها بعض الدول في هذا الإطار. وفي دول أخرى ذهبت إلى توسيع إطار المساءلة في القوانين الموجودة، يعني توسيع النطاق الخاص للمساءلة والمحاسبة، توسيع إطار عدم الإفلات من العقاب والتسامح الصفري مع مرتكبي الجرائم. وهذا أمر أيضا كان يعني انتهجته بعض الدول. الأردن لم يذهب بعيدا في القانون الخاص التنفيذي الشامل، فلغاية الآن لم يصدر هذا القانون ولم يعرض على البرلمان. عندما كنت عضوة ل3 دورات متتالية ول10 سنوات لم يعرض مشروع هذا القانون. ولكن لابد من الإشارة بأن هنالك قوانين وطنية عدلت بصورة تعزز سيادة القانون وتعزز عدم إفلات المجرمين من العقاب، ومع الأخذ بعين الاعتبار أن هذا القانون يطبق على كافة قاطني ومواطني الدولة الأردنية، وبالتالي تستفيد منه بالتأكيد اللاجئات والنازحات اللواتي يعني كما تعلمون أن الأردن يستقبل أكبر عدد من هؤلاء اللاجئات والنازحات، وبالتالي يمكن الاستفادة من المنظومة التشريعية الموجودة من أجل يعني قدر الإمكان تعزيز ثقافة محاسبة والحق في تقديم الشكاوى من قبل الجميع. طبعا أود أن أشير إلى أنه يعني كان في جانب مهم جدا لابد من التطرق له، وهو الجانب المتعلق ب الجانب يمكن اللي أشارت له الدكتورة سحر صديقتنا وزميلتي في الائتلاف، وهو الجانب المتعلق بتسييس في بعض الأحيان تسييس موضوع يعني المحكمة الجنائية الدولية وارتباطها في أذهان البعض داخل المجتمعات بأنها هي وسيلة يتم استخدامها اتجاه بعض الدول من أجل يعني المس بالسيادة الوطنية، وأن هذه الأداة لا يتم تطبيقها بعدالة على الجميع، ولا تدخل كل الدول ضمن إطار المحاسبة، وبالتالي تفلت الدول وتفلت بعض الكيانات كما يفلت بعض يعني الزعماء ولنقل قادة الحروب من هذه الجرائم، ولا يتم يعني مساءلتهم ومحاسبتهم. فبالتالي أعتقد بأنه من المهم جدا عند التساؤل عن دور البرلمانيين أن يكون هنالك دائما تركيز على هذا الجانب، تركيز على أهمية النظر إلى الجزء الممتلئ من الكأس. يعني عندما أشار ديفيد إلى أن هنالك 123 دولة الآن هي أعضاء في نظام روما الأساسي وفي المحكمة الجنائية الدولية، أنا باعتقادي أن هذا أمر يجب التركيز عليه، ويجب أن يكون هنالك يعني كشف لهؤلاء الذين لا يرغبون بسيادة القانون الدولي ولا يعيرون أهمية كبرى إلى حتى لو كانوا من الدول القوية والدول المؤثرة، ولكن من المهم أن يكون هنالك يعني توضيح وكشف وتعرية لهؤلاء أمام الرأي العام العالمي، لأنه هذه هي الطريقة الوحيدة التي ستعطي مصداقية للبرلمانيين في محاولاتهم للتمسك بثقافة القانون الدولي الإنساني والتمسك بفكرة العدالة للجميع وسيادة القانون على الجميع وعلى كافة الدول وعلى كافة الأفراد، وأن لا يفلت أحد من العقاب، وأن لا يتم توظيف واستخدام هذا النظام وهذه المحكمة لأسباب سياسية أو بطرق يعني غير قانونية بحتة، بطرق لا تتعلق فقط بسيادة القانون على كافة الدول. ومن هنا أعتقد بأنه مهم جدا يعني دائما الاستناد إلى القرارات الخاصة بمجلس الأمن وإلى ما أشار إليه أيضا الأمين العام للأمم المتحدة في تقريره لعام 2019 عندما تكلم يعني عن استخدام العنف الجنسي والعنف القائم على النوع الاجتماعي. وأنا أركز على هذان الأمران لأنه نحن ركزنا عليهم كثيرا في ائتلاف البرلمانيات العربية، استخدامهم كتكتيك حرب لإرهاب الأعداء بشكل منهجي وتأكيد السلطة على المجتمع. وأذكر جهودنا مع سفيرة العراق في الأردن في عام 2016 عندما قمنا نحن وهي في الائتلاف بإطلاق اليوم العراقي واليوم الوطني العراقي يعني مناهضة العنف الجنسي ضد المرأة العراقية، لأنه مرت العراق بظروف صعبة. وأذكر في ذلك الوقت أيضا جهود السفيرة والنائبة السابقة في البرلمان السيدة صفية سهيل في هذا الأمر عندما تكلمت ووضحت كم تعرضت النساء إلى أن يتم استخدامهن بصورة منهجية كأداة في الحروب ولتأكيد سلطة بعض هذه الجماعات الإرهابية على المجتمع ولكسر شوكة المجتمع إن صح التعبير. ولا يجب أن يكون أو أن تتم المصالحات بعيداً عن تحقيق العدالة لهؤلاء النساء، لأنه سيبقى الجرح يعني غائراً ونازفاً ولن تكتمل العدالة إذا لم تحصل هؤلاء النساء وهؤلاء الفتيات على حقهم العادل في محاسبة ومعاقبة ومساءلة كل من قام بذلك وسهل وفعل وقدم أي شكل من أشكال المساعدة أو تواطأ من أجل ذلك، وأيضاً الحق في جبر الضرر، وهذا أمر مهم جداً أيضاً تكلم عنه نظام روما الأساسي. من يعني يجبر هذه الأضرار التي تقع ويعني حتى يتم تجاوزها ويتم فعلاً إنشاء السلام على قاعدة العدالة وعلى قاعدة سيادة القانون. باعتقادي بأنه لا يمكن إلا أن يعني أن أؤكد على أهمية الحالة النموذجية، وهي صياغة تشريع تنفيذي شامل، يعني تشريع قابل للتطبيق شامل يشمل كافة الجرائم التي نص عليها النظام، وبالتأكيد الجرائم العنف الجنسي وجرائم القائمة على النوع الاجتماعي وأي جرائم أخرى زي جرائم الاغتصاب، جرائم الاستعباد الجنسي، الدعارة القسرية، الحمل القسري، التزويج المبكر، التعقيم، كافة هذه الجرائم التي فعلا يعني نحن في الأردن بحمد الله، يمكن لأننا دولة لم نخض يعني هذا النوع المباشر من الصراعات، ولكننا كنا ساحة لاستقبال اللاجئين الذين عانوا كثيرا من كل هذه الأشكال، والتي نجد بأننا من أجل أن يكون وبالتالي أنا أعتقد أن هذا الأمر غاية في الأهمية، وهذا الأمر يعزز ثقافة سيادة القانون داخل الدولة نفسها وذاتها. وبالطبع الأردن انضم وسينضم بوجود تشريع متكامل ضمن التشريعات الوطنية إلى الدول التي لن توفر فقط الحماية المجردة للمواطنين، بل ستعزز النظام القانوني المحلي بأكمله، وبالتالي لن يكون هنالك سماح بالإفلات من العقاب. من المهم جدا أن يبقى التحرك قائم، وخاصة مع الزملاء الجدد في البرلمان الجديد، ومن أجل التوعية بنظام روما الأساسي، وهذا أمر جدا مهم يمكن القيام به من خلال ملتقى البرلمانيات الأردنيات، ويمكن القيام به أيضا من خلال لجان المجلس المتخصصة. لدينا في مجلس النواب لجنة قانونية ولجنة خاصة بحقوق الإنسان والحريات العامة، وهذا بعتقد أنه أمر مهم جدا، وليس هنالك أيضا يعني شك بأنه لابد من إشراك المجتمع المدني الوطني، أن يكون هنالك فاعلين على الأرض من داخل المجتمع المدني الأردني يساعدون في خلق رأي عام يؤسس ويؤطر ويجمع الجميع حول ثقافة سيادة القانون الدولي الإنساني، وحول فكرة وأهمية الانضمام لمثل هذه الآليات الدولية، ليس فقط من أجل يعني تحسين الصورة والانضمام إلى هذا النادي الدولي، ولكن لأن في ذلك مصلحة إنسانية عظمى للشعب ولكل الناس. أود أن أشير سريعا بما تبقى لي من الوقت إلى عدد من النقاط الهامة التي اشتمل عليها اقتراحنا نحن في ائتلاف البرلمانيات العربيات حول هذا الموضوع، حيث أننا فعلا قدمنا في اقتراحنا لجامعة الدول العربية وعبر هذه الاتفاقية الآن التي تناقش الآن عند لجنة حقوق الإنسان بعد أن استكملت دورها في لجنة المرأة، أهمية أن يكون هنالك إطار تشريعي شامل لحماية النساء من العنف، لأنه في أغلب الدول يكون هنالك دائما حديث عن العنف المنزلي فقط. إذا نظرنا إلى الدول العربية نجد أن كل القوانين التي تتكلم عن العنف ضد المرأة تتكلم فقط عن العنف المنزلي أو العنف الأسري، وبالتالي لا يوجد إلا في تونس وفي المغرب قانون شامل للعنف ضد المرأة والفتاة يشمل كافة الأشكال، حتى العنف السياسي يشمل ذلك القانون. أيضا أن يكون هنالك إطار زمني، وأقول لكم هذا في الاتفاقية تكلمنا عن أن يكون تكون بنود الاتفاقية ملزمة في كافة الفترات، فترات السلام وفترات النزاعات المسلحة وفترات انعدام الأمن، والتنصيص على تدابير خاصة تشمل المدنيين والعسكريين وكافة المشاركين في النزاع. أيضا توفير حماية أكثر للضحايا من خلال التأكيد على قيام مسؤولية الدول بالقضاء على العنف والوقاية منه، وليس فقط التدخل بعد حدوث العنف، وهذا أمر مهم جدا، ويجب أن يكون ذلك أثناء النزاعات وإذا تم الفعل من قبل أي من الجماعات المسلحة غير النظامية أو حتى وحدات عسكرية أجنبية، وأن لا يعتد بأي اتفاقيات تعطي الحصانة والحماية لهذه الوحدات العسكرية الأجنبية، وأن يكون هنالك حق للمساءلة ولإنزال العقوبة ولمنح التعويضات لهذا الأمر. كذلك وضعنا بأنه يجب أن تلتزم الدول الأطراف بأن تتولى السلطة القضائية المختصة إثارة الدعوة من تلقاء نفسها، وفي عدد كبير من هذه الجرائم الموصوفة أيضا في نظام روما الأساسي، وعندما ترتكب الجريمة ينعقد الاختصاص للدولة عندما ترتكب الجريمة جزئيا أو كليا فوق أراضيها. أيضا يكون من المهم جدا، وهذا أمر نحن نعرف أهميته في الدول العربية، أن يكون هنالك إلزامية في مواصلة التتبع ومواصلة إجراءات التقاضي حتى لو تراجعت الضحية وسحبت الشكوى. وهذا نجد مهم جدا. لماذا؟ لأننا في الدول العربية كثيرا ما تتعرض النساء للضغط من أجل عدم التبليغ على هذه الأمور وهذه المسائل. أود أن أختم بالقول إلى أنه الأردن أيضا في إطار توسيع إطار عدم الإفلات من العقاب، وبعد التعديلات المهمة التي جرت في قانون العقوبات الأردني والتي قلصت كثيرا من ألغت تماما الأعذار المحلة وقلصت كثيرا من نطاق تطبيق الأعذار المخففة في الجرائم وخاصة جرائم العنف ضد النساء، فلا بد من الإشارة إلى أن الأردن أيضا اعتمد الخطة الوطنية لمتابعة قرار مجلس الأمن 1325، وأعلم بأن هذا الأمر يعني ذو علاقة ولكنه أمر منفصل عن نظام روما الأساسي. ولكن من المهم جدا أن نعرف بأن الاستراتيجية الأردنية ارتكزت على 4 محاور أساسية، هي تحقيق الاستجابة لاحتياجات النوع الاجتماعي والمشاركة الفاعلة للمرأة في القطاعات الأمنية والعسكرية وفي عمليات السلام، أيضا تحقيق المشاركة الفاعلة للمرأة في الوقاية من العنف والتطرف وبناء وصنع السلام الوطني والإقليمي، توفير الخدمات الإنسانية المستجيبة والمراعية لاحتياجات النوع الاجتماعي، تسهيل الوصول لها من قبل الفتيات والنساء الأردنيات واللاجئات الأكثر عرضة للعنف، وأخيراً تحقيق ثقافة مجتمعية داعمة لاحتياجات النوع الاجتماعي وأهمية المساواة بين الجنسين ودور السلام أو دور النساء في تحقيق الأمن والسلام. أنا لا أود أن أطيل أكثر من ذلك وأختم هنا، وأتمنى أن تجد الاتفاقية العربية التي وضعناها كائتلاف للبرلمانيات العربيات لمناهضة العنف ضد المرأة طريقها إلى الإقرار، لأنها ستساعد كثيراً في النزول من الإطار الدولي إلى الإطار الإقليمي وتسهيل إن شاء الله الوصول إلى الإطار الوطني في التشريعات، وهذا باعتقادي أمر غاية في الأهمية ومهم جدا، وسيسهل انضمام المزيد من الدول العربية لنظام روما الأساسي، وعلى أمل أن يحظى العالم بمستقبل أكثر أمان وسلام وأكثر عدالة، وأن لا تفلت أي دولة أو مجرم من العقاب مهما على شأنه أو كان مركزه. وشكرا جزيلا مرة أخرى على هذه الفرصة.
Wafa, thank you very much. That was so rich. And you may be pleased to hear that I was doing a video calls with political parties in Lebanon on Sunday, and I had a session yesterday in Khartoum, and I was using your example of how reforms can be implemented, and Jordan as an example in this area. So thank you very much. Melissa, we'll hear from you next, but if there are any honourable colleagues from Iraq who wish to make any comment or question, please indicate. And secondly, whilst Melissa is making her intervention, the PGA will take a screen grab of our session. So please, could people put their webcams on during the first part of Melissa's comments so we can capture as many handsome and attractive faces as we can on this call. Melissa, over to you.
Thank you so much, Jeremy. It's a pleasure to share this panel with Honorable Bani, who's very inspiring, and we thank her for her presentation, which laid emphasis on the importance of sexual and gender-based violence crimes when implementing the Rome Statute domestically. And as we all know, sexual and gender-based violence crimes are used as tools of war. And we've been inspired by the work of individuals such as Yazidi human rights activists Nadia Murad and Lamia Haji Bashar, who was awarded the PGA Defender of Democracy Award in 2017, and also Nobel Peace Laureate Denis Mukwege in the DRC. So my short presentation, I hope I'm not going too fast and that the interpreters are able to follow, is about some best practices on how to advance the fight against impunity for international crimes. As was mentioned in previous presentations, some countries in the region, like Jordan, have ratified the Rome Statute, but they do not have an implementing legislation. And other countries have neither ratified nor implemented the Rome Statute. So I will speak about 5 mechanisms, I would say, recommendations that assist in fighting impunity for international crimes. So the first one is, as mentioned previously, fully implement the provisions of the Rome Statute in the domestic legal order, even if you have not ratified yet. I think that always strengthens the domestic institutions and in particular the judiciary. So international crimes, genocide, crimes against humanity, war crimes, and the crime of aggression are egregious. They are so severe that it's important to realize that they not only affect the victims or the countries, but all humanity. And in that sense, states should ensure that national criminal codes and their codes of criminal procedure includes the crimes described under the Rome Statute. And national jurisdictions, in compliance with the principle of complementarity that Rod has emphasized in his presentation, should have the legal framework to investigate and prosecute, because they are the primary actors responsible to investigate and prosecute international crimes and cooperate with the ICC. And the ICC will not try most cases. And we've heard in Rod's presentation the challenges that the Office of the Prosecutor is facing in terms of investigating cases. And the ICC is only a court of last resort. So truly states are responsible first and foremost to investigate individuals responsible for international crimes. The second mechanism, I would say, or the second principle, is really to make use of universal jurisdiction. So universal jurisdiction allows states to claim criminal jurisdiction over an accused person, regardless of where the alleged crime was committed and the nationality or country of residence of the accused individual. So the underlying idea is that some crimes are against all humanity, and consequently, impunity for such crimes cannot be tolerated. So we're all concerned. To illustrate the use of universal jurisdiction, we can take 2 examples shortly. First of all, for instance, Germany. Under German laws, universal jurisdiction is recognized for the most serious crimes under international law. Therefore, allowing Germany to investigate and prosecute these crimes, no matter where they have been committed or regardless of the nationality of the victims or alleged perpetrators. I know that a recent case in April, it's qualified as a landmark case, which started in April, where two individuals, allegedly former Syrian officials, were accused of committing crimes against humanity. And the trial of these individuals was possible under universal jurisdiction. So the higher regional court in Koblenz convicted, I think on February 24th of this year, one of the individuals, a secret police officer who aided and abetted crimes against humanity, and he arrested and transported protesters in interrogation centers for torture and other unlawful acts. The defendant, Ayad Al-Gharib, was sentenced to 4.5 years in prison. So he's the first former Syrian official to be convicted of crimes against humanity in a case that rights groups have hailed as landmark in the effort to ensure justice for violations committed during Syria's civil war. The second example that I can take is Finland. In 2020, a Finnish court started prosecuting a national of Sierra Leone, I think Mr. Jabril Massaquoi, who is accused of war crimes allegedly committed in Liberia between 2001 and 2002. It's a first of its kind. The court will temporarily relocate to Liberia and Sierra Leone for part of the trial to resolve the difficulty of moving witnesses from these countries to Finland to testify, especially following the outbreak of COVID-19. And yes, the pandemic has had severe consequences worldwide, including on the judicial processes. And this accused person is accused of killing civilians and soldiers who had been disarmed. He's accused of rape and also recruitment of child soldiers. So that's the second mechanism, universal jurisdiction. The third one is not so much in terms of individual accountability, but state accountability for alleged international crimes. I can state the case of Myanmar and the Gambia before the International Court of Justice. As you know, the International Court of Justice was established in June 1945 by the UN Charter and began its work in April 1946. So in the Myanmar and Gambia case, so on November 2019, the Gambia, a very small country, filed an application at the International Court of Justice against Myanmar, alleging violations of obligations under the Genocide Convention. So this is more of there is evidence of a more state-sanctioned genocide of the Rohingya population in Myanmar, and the Gambia asserts that the prohibition of genocide is a jus cogens norm and results in obligations, erga omnes and erga omnes partes, basically big words to say that obligations arise towards the international community as well as the parties to the convention. And last year, the International Court of Justice issued its decision requesting provisional measures to prevent further crimes being committed against the Rohingya. Of course, the applicability of this is more difficult, but the court requested these provisional measures. The fourth mechanism that I can mention to assist with judicial proceedings, we need evidence. The example of the two examples. The first one is the International Impartial and Independent Mechanism, so called IIIM, and the Tunisian Truth and Dignity Commission. So for the IIIM, International Impartial and Independent Mechanism, it was established under the United Nations General Assembly in December 2016 to support the investigation and prosecution of persons responsible for international crimes committed in Syria since March 2011. We know that Syria is a case that is truly devastating. The mandate of this mechanism is to collect, consolidate, preserve, and analyze evidence of violations of international humanitarian law and human rights violations and abuses, and to prepare files to facilitate fair and independent criminal proceedings in accordance with international law standards, also national, regional, and international courts. Although this mechanism is not a court, the evidence against the Assad regime, the evidence collected, is truly overwhelming. And consequently, in September 2020, that has prompted, for instance, the Netherlands to announce a decision to hold Syria responsible under international law for gross human rights violations and torture under the UN Convention Against Torture. The second mechanism that I can mention more closer to the region, I would say, is the Truth and Dignity Commission in Tunisia. Tunisia adopted in 2013 a transitional justice law to address human rights violations and corruption between 1955 and 2013. So the law established the Truth and Dignity Commission with a 4-year mandate, renewable for 1 year, to investigate, expose the truth, propose measures for accountability, remedies, and rehabilitation of victims. On 26 March 2019, the Commission made public its 5-volume report analyzing and exposing the institutional networks that enabled human rights abuses over 5 decades. The Commission outlined the role of former presidents and other top officials who are involved in torture, arbitrary detention, and other serious human rights abuses. The Commission documented abuses against political opponents, their families, including sexual assaults of wives and daughters of opposition members. And they also included several recommendations to Tunisian authorities to end impunity and ensure accountability for alleged perpetrators. To give you a sense of the magnitude of the cases that were brought, so the Commission transferred 173 cases to specialized criminal chambers after receiving more than 62,000 complaints from victims, and at least 78 trials involving cases of torture, extrajudicial executions, and enforced disappearances began before these chambers. And I must commend Tunisia because it's the only country to establish a National Truth Commission in the wake of the Arab uprising, only second to in the Middle East and North Africa. The first one was Morocco, with its Equity and Reconciliation Commission established by King Mohammed VI in 2004 to investigate some abuses under the rule of his father. The fifth mechanism that I can mention, and it will be my last point, there is a regime of sanctions. So parliamentarians can adopt, or can at least attempt to discuss this with their executive, Magnitsky type legislation as a tool to fight impunity by punishing individuals or corporations responsible for serious human rights violations, and also in some cases corruption, that are often linked to serious human rights violations. These sanctions are based on travel and visa ban, asset freezes, and they provide a deterrence effect because a lot of perpetrators have ties with money, and so it's difficult for them to see certain privileges go and certain aspects of their financial life that funds these serious human rights violations. And I can cite countries like Canada, like the US, the UK, Estonia, Latvia, and more recently the European Union, who has adopted a global human rights sanction regime and also some legislation. We can cite as an example of use of these sanctions, Canada and the US have recently imposed, for instance, sanctions on the Chinese government, some Chinese government officials for serious human rights violations committed against the Uyghurs in Xinjiang. So to end my presentation, parliamentarians have an essential role to play in fostering political will with their not only with their governments, but also raising awareness with their constituents. Accountability is also about the value a nation places on the lives of its citizens and building resilient national judicial mechanisms with proper resources to respond to international crimes. The most innovative, I think, aspects of the Rome Statute, and to echo a bit the presentation of Honorable Bani, is the participation of victims in proceedings. And I think that a lot of aspects of the Rome Statute can be of use to Middle East and Northern African countries and carried out at a domestic level. Thank you so much.
Thank you, Melissa, for those 5 points. Thank you. We are behind time, so I'll just perhaps go straight on to Professor Leila Sadat, and then from that we can have some closing remarks from David. But Professor Leila Sadat, I think will follow from Melissa's point, perhaps, is the James Carr Professor of International Criminal Law at Washington University, and is of the US branch of the International Law Association. So Professor Sadat, over to you. Delighted that you're here.
Thank you so much. Can everybody hear me okay? Yes. First of all, thank you so much to PGA and to David for the invitation to be here. The work that PGA does is critically important in sustaining the energy that went into the establishment of the International Criminal Court, and to keep the dream going, if you like, of a court that would one day have universal adherence and universal ratification. So thanks to all of you who are here, and especially for PGA to have convened us. By way of background, I am also a special advisor to the International Criminal Court prosecutor on crimes against humanity, and I have proudly served for the past 9 years in that capacity. I may touch upon in these short comments the sanctions, because I too have been affected by the sanctions regime applied to the court. And I very much heard Susan Power's plea to allow civil society to do their jobs, which is to promote accountability actually and work for justice, free from the threat of prosecution or government interference. I've been following the work of the court for over 25 years, since the establishment at Rome and even prior to Rome. And it's thrilling to see how the court has grown in spite of the struggles that it has had with some governments, including my own. I have a connection, I should say, to the MENA region. As you may have guessed from my name, my father is Syrian and my mother is American. And I was born in the United States and have a very poor comprehension of Arabic, although I have some. So forgive me speaking in English to this esteemed group. The court is an institution established to be independent in all cases. And for that reason, Prosecutor Bensouda has said it will pursue its mandate. She will pursue her mandate without fear or favor. And that is a very, very difficult mandate to exercise in the wake of sometimes overwhelming political obstruction. But I think she has, in fact, followed that mandate scrupulously in spite of being underfunded. And I agree with Rastan. You will be interested to know that the Manhattan District Attorney of New York has a budget of $149 million, plus they get asset forfeitures. So, you know, for a court that potentially could cover 7 billion people, to have a third or a quarter of the resources of one city in the United States, you can really see the contrast. At the same time, we work with what we have. And when I speak to my American colleagues, what I try to say about the court is you have to understand it not as a sword attacking individuals, but as a shield that protects the territories of states that ratify the ICC statute from commission of those crimes on their territory, and also obliges the individuals in those states not to commit ICC crimes. That means that all states that want peace and justice should see ratification or accession to the ICC statute as a positive, as a plus, because it's protective of the territory of those countries, it's protective of the nationals of those countries, particularly women and minorities who might otherwise not be protected, and all states that love peace and justice, and I know that that includes all of your governments here, should embrace the ICC then as sort of a tool in the arsenal of tools that you have to promote peace, to promote justice, to promote accountability. In my own country, one of the things we are working very hard with the new administration on is to get the sanctions reversed, of course, because they are not consistent with the rule of law. and to promote not just a reversal of negative actions on human rights by the United States, but positive actions. And the recent appeal in the Nidaganda case that affirmed that Nidaganda would, in fact, his conviction was affirmed and he was sentenced to 30 years. The United States was instrumental in actually apprehending him and handing him to the court. And our former ambassador for war crimes has made an excellent statement saying this is exactly the kind of thing that the United States needs to be doing. It needs to be helping the court, and it needs to reverse the sanctions. So trust me, we're working as hard as we can in our country to make sure that the new administration hears this and that the sanction regime will go away and the United States can be a positive force. We are really trying to reopen that conversation. Finally, let me just say one more word about implementation of Rome Statute crimes. I heard very strongly the testimony of several of you about implementation in your own countries, and that is a critical element. National parliaments have a crucial role to play in enhancing peace and justice by implementing in their national parliaments Rome Statute crimes. We're now working in the United States to get crimes against humanity legislation adopted. We had started in 2010, and then a new regime came in our country, as you may know, and that project had to be put on hold. It's now been reintroduced. A prominent senator, Dick Durbin, who I believe is a PGA member, is going to reintroduce that legislation. And that leads me to one final point, because I know time is short. I would really urge all of you to consider when it comes to the United Nations this fall, and I'm happy to answer questions offline. There is an International Law Commission project for a new convention on crimes against humanity that would essentially track the Rome Statute, that does allow for ICC non-states parties to essentially take baby steps towards implementation of the Rome Statute by adopting a new treaty on crimes against humanity, which would be added to the Genocide Convention and the Geneva Conventions on war. And I urge you very much to speak amongst yourselves and to your governments to consider supporting that new initiative. There has been some support from the MENA region, but it would be great to have much more, because it is a region that is influential, where these crimes have been happening on and off in various locations. And I know that this group has a deep commitment to peace and justice, and this is part of that effort. Finally, I'll just conclude with this note. I feel very much the spirit of Professor Sharif Bassiouni with us today. I was not a student of Sharif's, but a young colleague of Sharif's. David and I worked with him together in the Rome Conference. He, of course, was from Egypt and hugely committed to the well-being of people in the MENA region. And I know he would be thrilled by this meeting today and thrilled to see the efforts of all of you to carry the dream of Rome forward in your own countries and for the international community. So I think I'll stop there. And again, my deepest regret, I could not address you equally in Arabic, but thank you so much for the opportunity to be here. Shukran.
Thank you, Leila. Before I finally ask David to make a closing remark, we may have 1 minute. And it was just checking if the Honourable Mustafa or Honourable Member in Iraq are present and would like to make a contribution. Please turn on your webcam and microphone now if you wish. If not, then you can certainly be in contact with us and David and the team direct, and we can follow up any of the points, especially from Leila and Melissa, on practical steps. But some closing comments now, some brief closing comments from David, please.
Yes, thank you, Jeremy. And really, I'm humbled by the inspiring words by Professor Sadat, who's also the president of the American branch of the International Law Association. So I trust that she can influence a lot of people in Washington and carry on with the teachings of Professor Bassiouni, who, let's remember, was the chairman of the drafting committee of the Rome Statute. So it was an Arab jurist that was the main drafter of the Rome Statute in 1998. Let's not forget this. And yes, his efforts to get his own country, Egypt, to join were vanified by the leadership of the time. But I hope that things will change again and democracy will be back. And we support in PGA human rights, the rule of law, justice, but also democracy. And this explains why so many Arab countries are not represented in our working group, because we don't believe that some of those countries are really democratic, have elected parliament. Until they will not have them, I'm afraid they will not be able to join our membership. I think we had very precise action point out of this meeting, and we really hope that in Iraq we will be able to work with the Parliament of Iraq and with you, Jeremy, together with you and your colleagues, Honorable Redvar, Honorable Hamed Nassar, and the Secretariat of the Parliament, who is really eloquent and well-trained, to find ways and means to promote accountability, because so many people in Iraq from all sides have suffered for too long under the dictatorship, under various wars, and now under a very difficult situation where the first victims are the innocent civilians. So as demonstrated by the recent visit by His Holiness Pope Francis to Mosul, there is hope for the victims from all minorities, not only the Christian ones, and also from the majority who has been victimized, either the Shia Muslim or the Sunni Muslim. And we really want to work for peace, justice, truth, and reconciliation. All things go hand in hand. And we don't believe that counterterrorism is enough to deal with justice. That's absolutely not sufficient. And going to Yemen, we are also committed to work with our members to assist them in the peacemaking process, because there has to be now peace with justice and an end to the war, and all the efforts that have been mentioned regarding, which Rod mentioned, regarding the selling of weapons to Saudi Arabia and the United Arab Emirates, which are pursued in Western Europe. These are things that have gone now mainstream thanks to the policies of the new president of the United States. And I think they should be pursued, and the stabilization of and peacemaking process in Yemen should go hand in hand with justice and accountability. For Jordan, we heard really a very strong commitment towards the domestic implementation of the Rome Statute, starting with the crimes of sexual and gender-based violence, which are a promise of reform for a country, Jordan, that was enlightened and that the reason to join the Rome Statute, among the first being Prince Zayed Al Hussein, His Royal Highness, the first president of the Assembly of State Parties in 2003, if I'm not mistaken, or just at the end of 2002 already, he became the first president of the Assembly of State Parties. So Jordan is really an example, and we really would like to work with the organization of Honorable Wafa Bani and our colleague Samia Smadi, who is with us, who are women engaged for the support of gender equality and equal opportunities. And I also recognize that Honorable Dina Anvir Al-Bashir is with us, another member of parliament from Jordan, and we would be also honored to continue to work with her. And in respect to the situation of the region as a whole, which includes situation countries like Palestine. Palestine joined, and the court is working on the situation. The court is working maybe on the situations linked to the deportation of Syrians into Jordan. That's maybe more forward-looking than present. But we would like to continue to work with the members of the future Legislative Assembly of Palestine and any other parliament in the region to ensure that justice is done. And if I can say only one word to close the remarks that have been made on political issues, big political issues that are surrounding the pursuit of justice. I think we should be very happy of where we are today, because today we are confronted with campaigns against the ICC, against justice, done in the face of the prospect of investigations. We are not facing a retaliatory act, the launch of missiles, suicide bombers, and things like that that we have been facing in the past. That gives us a reason to tell, for example, Israel to ratify the Rome Statute, or the United States to ratify the Rome Statute and join the fight for justice, peace, reconciliation, truth, and stability in the global community. So we are committed to this goal all together. And I think peace and justice in the Middle East may mean peace and justice in the world. And I take from this working group that we have a lot of work to do, and PGA is at your service to continue the fight. Thank you. Thank you to all.
David, thank you very much. Thank you, honourable members, colleagues, parliamentarians, for attending. Thank you for the expert contributors that have been so informative. And thank you for David and your PGA team for bringing the session. You said there is much more to do, quite right, and that task is ahead of us as parliamentarians, but this session has helped us and informed us in our work. So thank you all, and I hope that our next sessions can be in person, but in the meantime, and until then, I hope people stay safe, and I close this 8th working group session. Thank you.
Thank you.
Thank you. Thank you very much. A big thank you to the interpreters and to all of you.